We want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have interesting cases, good lawyers. And in the first case, Mr. Black versus the Securities and Exchange Commission and others. Mr. Dinar.
Yes, Your Honor.
Good to have you with us, sir.
Thanks.
You may proceed.
Good morning, and may it please the court. Adi Dinar for Frank Harmon Black and Southeast Investments NC Inc. I want to make 3 quick points, and then I'll be happy to address anything that is on your mind. First, the 4 structural constitutional claims presented here do not need to be exhausted, as Carr versus Saul, Freitag, and PHH Corp hold, and as Axon confirms.
You say they don't have to be exhausted. By that you mean you didn't have to present them below. That you can come up here and ask us to decide 4 constitutional questions without having them been presented to or argued or resolved in the underlying proceedings. That's,
Yes.
That's pretty much a stretch, in my experience. Go ahead.
Well, Your Honor, I'll call your attention to Carr versus Saul and Freitag, where the parties presented the structural constitutional claims for the first time in the first available federal court, and the Supreme Court had no trouble deciding the constitutional issues because they go to the validity of the ensuing and underlying non-Article III adjudication. In PHH Corp is an en banc unanimous DC Circuit decision in which, again, the same thing happened. The parties presented the structural constitutional claims for the first time.
Well, did that case deal with a statutory exhaustion requirement? I thought it dealt with a judge-made type exhaustion rule. Is that not a differentiation?
I don't think so, Your Honor, because the statutory exhaustion requirement here comes from Section 78Y. In PHH Corp, it was a case against the Consumer Financial Protection Bureau. There is a statute that relates to the CFPB, which looks similar to the statute at issue here, and the DC Circuit en banc unanimously rejected any need.
Well, those cases dealt with the judge-made exhaustion requirement. Give us one that deals with the statutory exhaustion requirement.
Well, these are all
Fulfills
common
your
law.
purpose.
Well, these are all common law exhaustion requirements because the statutes ultimately rely on or borrow from the common law exhaustion requirements. So the reasonable grounds statute, which is at issue here, is very similar to the statute at issue in the CFPB case. In the Carr versus Saul case, which is a case relating to the Social Securities Administration. So there has been an unbroken line of cases from the Supreme Court and in the circuit courts that do not require exhaustion in this case. The second point I wanted to make, Your Honors, was that the 7th Amendment and Article 3 require Article 3 courts and juries to decide suits involving private rights like this one, as SEC versus Jarkissi holds. And the third point I wanted to make was was about private non-delegation. FINRA is a private organization that Black and Southeast are compelled to join by federal law, but FINRA exercises governmental powers, and there is no practical and no pre-deprivation SEC supervision or oversight, and that violates the private non-delegation doctrine, as has been held repeatedly by the Supreme Court, by the 5th, 6th, and 8th circuits, and most recently, only a few days ago, by the DC
How
Circuit.
do we even have jurisdiction at all? How is the order subject to review when part of it was remanded? How is it a final order?
Well, the SEC's decision is on the merits, and that shows
It was
the
not on the merits. They remanded it.
that is a decision on the merits.
They remanded
Correct.
for more work on this evidence question.
Well, so there's the remand portion of the SEC's decision, and there is the affirmance portion of the
Well,
SEC's
it's
decision.
not a final order because it's non-final. It's fine, you're arguing it's final in part and we can pick and choose. You're saying it's a piecemeal jurisdiction situation. And we generally don't do that. We review final orders. That's the standard that we've been applying for as long as I've been around.
Well, the finality.
That's the position taken by FINRA. They're an intervener here. And they've devoted, they're briefed to that point. And you haven't responded to it.
Well, we responded to
You basically ignored it.
Well, so the finality, I mean, I understand typically in the petition for review setting, finality is one of the issues, but let's imagine what the word looks like if we go back in front of FINRA. They will be deciding pure questions of law.
It's back in front of FINRA.
Well, correct, that's the relitigation remand, and we would be presenting the 4 structural constitutional claims in front of those FINRA adjudicators.
For the first time.
Well, we also have the federal district court case, but what I'm trying to get at, Your Honors, is the finality doctrine, or that argument, is mostly a distraction because, as Axon confirms, the United States Supreme Court.
The finality doctrine is what'd you call it?
I'm sorry, I said a distraction.
A distraction. Okay, that's what I thought.
Perhaps.
And that's probably something new in the red courtroom for the finality doctrine to be called a distraction in this room.
Well,
I've been hearing cases in here for years and years.
I understand, that's a heavy word, but I do think that the core of the structural constitutional claims go to the validity of the ensuing non-Article III adjudication. So structural constitutional claims have been different for many, many years because they aren't about this or that order that the non-Article III adjudicator enters. It's about the validity of that adjudication to begin with. So I understand the court's skepticism.
The SEC's position that this order, the portion of it that deals with the order itself is final, but the remand is not final. In other words, basically there's a split in terms of how we view the finality of this order. What do you think of that position?
Well, we disagree with that position because I think the relitigation remand is what necessitates.
Intuitively, it makes sense. I mean, that the portion of the order that actually delineates final relief is final, and that's remanded is not. But so why should we treat it one way or the other? That is either all final or it's not final because of this different ruling here.
Well, because that constitutes the consummation of SEC's decision-making process. So I think, perhaps it would have been smart for the SEC to simply affirm on both sets of claims, both the misrepresentation claim and the inadequate supervision claim. But with the relitigation remand, the SEC has informed all of us of their views about the validity of the adjudication to begin with. And I think that's the core issue here is the nature of the claims do matter for both the exhaustion doctrine and the finality doctrine. The Seventh Amendment is a structural guarantee that requires, mandatory is the word that SEC versus Jarkissi uses from the Supreme Court. It is mandatory for Article III courts to decide suits involving private rights. It is mandatory. That's a pretty strong word. Again, talking of strong words.
And this is the first, you're going to start in this court. And then you file a separate lawsuit somewhere?
We have a federal district court action that is stayed by agreement of the parties at the moment.
In the Western District of North Carolina. You filed a separate lawsuit about this stuff. Out there, and that's what we normally do. We review what the lower courts do, what the agencies do. And the district court in Western North Carolina hadn't decided any of this stuff.
Well, that's one way that this court receives cases is from the federal district courts, but the other way that the court receives cases is this appellate review model. It's Section 78Y.
And they review final orders. And you don't come up here with a final order.
Well,
I mean, that's
portion of the order is final, and
a portion is final, and we review final orders that are final.
And I think both the final portion and the non-final portion gives rise to the same issue because we are challenging the validity of the ensuing and underlying agency adjudication. So even if this were a situation where SEC for itself found facts, held an evidentiary hearing, we would still be here on the exact same claims. So the finality is, again, I keep repeating myself, but it is a distraction for purposes of the.
It's about our jurisdiction to hear the case at all, so I'm not sure I understand why you keep calling it a distraction. My question is, what is your best case for how we could sort of split the order and review the part of it that involves sanctions and then not review the part that was remanded?
So I think, Your Honor, you need to look at Alpine Securities from the DC Circuit, which is the most recent pronouncement on this point. In Alpine, there was, I grant you, it was an appeal from a preliminary injunction, denial from the district court. But I think all of these cases are reaching structural constitutional issues that are presented without regard to any exhaustion or finality requirements in the non-Article 3 adjudication. And the other set of cases, Your Honor, I would mention are the private non-delegation cases that have been decided by the 5th, 6th, and 8th circuits that are up on pending cert petitions in the US Supreme Court. They all point, again, in the same direction. Axon Enterprise versus FTC, which is a combined case with SEC versus Cochran, that the US Supreme Court decided in 2023. Again, the same thing. The nature of the claims do matter. If a claim is wholly collateral, as it is here, then simply the court looks at whether the claim is wholly collateral, if there is any agency expertise. Because if we go back in front of FINRA or SEC, what are they going to say? They are going to decide questions of law, and looking at cases like Loper Bright, deciding questions of law is quintessentially a judicial function. And that is essentially what we're asking the court to do, is to decide the questions of law that go to the validity of the ensuing and underlying agency and private adjudication. I quickly wanted to touch on the Seventh Amendment argument because I think that's important in the time that I have left. The Seventh Amendment, as
Is there a
Jarvis...
claim here for more than $20? Is that what you're claiming?
I'm sorry, Your Honor?
Is a claim here for more than $20?
It was a $250,000 fine that FINRA imposed initially, and the SEC affirmed $73,500, so it's way beyond $20.
Is that part of the remand?
No, it's on the affirmance portion. They levied a $73,500 fine. And that's the dispositive factor, according to Jarkissi, is the monetary portion. It's all but dispositive, as SEC versus Jarkissi says. And then the cause of action is merely confirmatory. It merely confirms that this is, in fact, a suit at common law that requires a jury trial. And if you look at the causes of action, the affirmance portion, which is the inadequate supervision, because an employee lost 16 emails that were to his wife. They were not business-related emails, but the inadequate supervision cause of action comes from the law of master-servant, the law of principal-agent, and the respondeat superior doctrine. And the misrepresentation regarding office inspections, that's the remanded portion of the decision. That, again, is a fraud, perjury, forgery-based cause of action, which comes from the common law. So the causes of action merely confirm that the monetary damages suit against Mr. Black and Southeast is a suit at common law that requires a jury trial in Article 3 courts.
Do you concede or agree that FINRA is a private entity?
It is a private entity that exercises significant governmental powers, and that comes from sections 78S, subsection G1, and 78O-3, subsections B7 and B8. FINRA does exercise significant government power. They investigate, they make the prosecutorial decision, they adjudicate cases, and then they levy fines, all without any meaningful SEC supervision. As Alpine Securities...
Have we ever applied constitutional structures requirements to an entity that was not governmental?
Well, yes. If you're talking about the private non-delegation doctrine.
Tell me the case we've done that.
Carter Cole and the HISA cases, the horse racing cases, are all cases dealing with private entities exercising significant governmental power. And those are private non-delegation cases, and the courts there have said that there is no non-delegation violation because the rules issued by these private organizations are reviewed and approved and only then go into effect. But here, that is not the situation. FINRA's decision against Black and Southeast goes into effect immediately, even before you can obtain an interlocutory expedited stay from the SEC. Mr. Black remained expelled from the financial sector for 4.5 years that SEC took to decide the merits portion of this decision. They denied the stay application. So this is definitely.
So your action is an action against the private entity directly. And the cases you point out deal with private non-delegation type claims. In other words, the agency, question whether the agency delegated too much power. Isn't that a differentiation?
So those cases are against both the private agency and the private organization and the relevant federal agency. So the Federal Trade Commission is involved in those cases, for example. So the private non-delegation claims are typically against both the federal agency and because the federal agency is doing the delegating as well as Congress is doing the delegating by promulgating statutes.
But it's still, I'm confused, at least in terms of whether you can bring a claim directly against this private entity in the absence of the agency aspect of it.
Well, there's no, I mean, the SEC is here, so the agency is definitely involved in all of these cases. They get to present their well-considered opinions to the court, and then the court under Loper-Bright decides for itself what the statutory scheme means and whether that violates the constitutional structure.
The point I'm making is it seems like in those cases the question was whether the agency had delegated the power to this private entity. That's not the question here.
Well, so in those cases, there is a statute, the Horse Racing and Integrity Safety Act, which in part delegates the government's powers to the private organization, the rulemaking power to the private organizations. So in the private non-delegation cases that I cited, it involves both a congressional delegation of power and under that same statutory scheme, a delegation of power from the agency to the private organization. And the same situation is present here. I see that my time is expiring. If there are no further questions, I would like to come back on rebuttal. Thank you.
Thank you, sir. Ms. Dixon?
Good morning, Your Honors, and may it please the Court, Courtney Dixon for the Securities and Exchange Commission. The only issue that is properly before this Court on direct review from the Commission's order is the Commission's conclusion that the petitioners committed the disciplinary violations for supervisory and record-keeping violations. Petitioners raise additional arguments about FINRA's disciplinary actions for allegedly lying to FINRA. That was remanded. There's no final decision before this Court. Petitioners also raise a host of constitutional issues, but as Your Honor's questions have noted this morning, they did not exhaust those issues before the agency. The statute requires that issues be exhausted before the Commission. The statutory bar has been universally recognized by courts to...
Why should we take this in a piecemeal fashion? That could be what limits this from having several parts of it. Some of it could be final, some not final. Why would we do that?
So on the finality issue, Your Honor, I mean, the Commission had before it, again, certain disciplinary counts by FINRA. The Commission determined that the petitioners committed the disciplinary violations for the supervisory and record-keeping counts, and it concluded that they had violated FINRA rules, and it affirmed FINRA's sanction for that. That's the Commission's final decision on that, and unless this Court reverses, the Commission is not going to reconsider that. The other issues are not before this Court. They've been remanded to FINRA. There'll be further proceedings, or FINRA could decide not to pursue those claims at all. That's a canonical example of a non-final order.
But then what is your best authority for us reviewing a case like that in piecemeal fashion in the way that Judge Nguyen described?
Sure. The Saliba case, Saliba versus SEC from the Ninth Circuit, similar posture as here. There were kind of multiple disciplinary counts before the Commission. The Commission kind of addressed one of them in a final order, and it sent the others back, and the court said because the commission's order is final in part with respect to the sanction, you can review that part of the commission's order, and then it remanded the others. I'll also just emphasize, the breadth of petitioners' arguments. They do not cite any case that supports their conclusion that this court can exercise review over all aspects of the order simply because there was a remand. And on petitioners' telling, if the commission had set aside all of FINRA's sanctions, remanded for further proceedings, and said, go back to FINRA and do this all over again, petitioners' theory would mean that they think that they could be in this court on unexhausted constitutional claims. That's not how this direct review statute has ever been understood. On the constitutional claims, again, the statutory exhaustion requirement has been universally understood to include constitutional claims. Courts have rejected the arguments that petitioners present here, that structural constitutional claims kind of categorically qualify as a reasonable ground. I'll also emphasize that in their opening brief in this court, petitioners did not raise any reasonable grounds that might excuse their forfeiture. They waited until their reply brief even to make those arguments. So those constitutional claims are not before this court.
You're saying that they didn't raise this exhaustion or structural claim until the reply brief?
They didn't, so they argue that they had a reasonable ground to excuse their forfeiture. It's their burden to show that. In their opening brief, they raised no such argument. So I think even in this court, trying to say that they can be in this court, they waited until
If you don't raise it in your opening brief, you waived it. Is that,
Yes, Your Honor.
That's the point? There is a
Yes, Your Honor, that's the
principle of
point
law
that I am
right there.
making.
But-
And I don't, go ahead.
I'm sorry, you go ahead.
No, you go ahead.
But why is it that the SEC and FINRA take different positions on this jurisdictional position?
Your Honor, FINRA is a private entity. It's privately represented.
But we are got all kinds of authority up here. We review final orders. We go to the exceptions or, injunctions sometimes, and collateral order doctrine.
I certainly agree with the principle that Your Honor is
But-
stating,
but-
that this court
but we
reviews.
We don't do things in a piecemeal fashion.
I think in this,
Here, they affirmed part and remanded part.
again, Your Honor, I would point the
It's not
court,
over.
I would point the court to the Saliba
But
case.
they didn't raise any of this stuff about the Constitution, but what they did was, it's not over.
So I think with respect to, again, the commission's conclusion that with the disciplinary sanctions for the record-keeping violations and the fact that they didn't have correct supervisory procedures, the commission issued a decision on that saying, yes, they committed this misconduct and affirming FINRA's sanction.
But we're a court of review, not of first view. That's a settled principle up here.
Yes, Your Honor, and this court would review the commission's conclusion that petitioners committed those disciplinary sanctions. If Your Honor is referring to the constitutional claims, I certainly agree that this court is a court of review and not a first review, and they did not raise those arguments to the commission. I'll note, petitioners invoke repeatedly Axon. That has nothing to do with the posture that we are in here. That case addresses whether certain structural constitutional claims with respect to ongoing administrative proceedings can be brought in district court in the first instance.
Well, you refer to the Saliba case, which supports your position, Ninth Circuit case. Fair enough. Judge King is going to the question, ultimately, what would be, not just wrong, but why couldn't we just wait and decide it all at one time?
Right, so I think the
And
Saliba...
what is the reason we would not do that?
I think the Saliba case speaks to this, Your Honor. The court notes, look, the commission had, again, multiple claims before it. It made a conclusion about these disciplinary violations, and the case is going back to FINRA. FINRA could decide not to pursue anything about the other disciplinary charges. That's why that portion is non-final. But if that happens, it's also possible that the other claims, which the commission has reviewed, they could not be before this court perhaps a second time if the commission were not to pursue the other claims on
But the
remand.
intervener distinguishes Saliba by noting that that decision was made without sort of adversarial briefing and with the support of both parties in terms of jurisdiction, and also that in that case, there was an immediately effective bar from FINRA membership, which the court analogized to an injunction. So that's not the case here, is it? Doesn't that distinction make a difference?
The court stated that part about the injunction, Your Honor, in a footnote to say it further supported its conclusion. And Again, in the commission's view, this is the commission's final word with respect to the disciplinary sanctions. We think, of course, only the merits of that are before the court. There was substantial evidence supporting the commission's conclusion. The commission's conclusion was reasonable. Petitioners do not present any arguments to second guess the commission's conclusion in that respect.
What would the problem be for the SEC if we just waited and heard the whole thing together instead of just heard the one part now?
My only response to that, Your Honor, and I'm not saying that it's necessarily going to happen or it's necessarily likely, but if, for example, this court sends everything back to FINRA and FINRA says, you know, we don't actually want to pursue the other disciplinary claims against petitioner for allegedly lying to FINRA, it's possible that there wouldn't be then another commission order before this court to directly review, because again, the commission has made its final determination on this. It's not going to reconsider it unless the court reverses. And I think that's maybe the crux of the distinction between us and FINRA, but we certainly agree that a remand order is the canonical example of something that's non-final. This court doesn't have jurisdiction over the portions that are remanding to FINRA, and the statutory exhaustion bar precludes petitioners' constitutional claims in this court.
Just remind me, the portion that's remanded, has that been stayed, with the hearing there, pending the outcome of this case? Because it seems to be, you seem to be saying there's some intersection of how we might rule that could influence the remand, or is there somewhere?
I mean, the commission set aside the penalties that FINRA had imposed for allegedly lying to FINRA that would go back before FINRA. My point, Your Honor, was
Has that been stayed? In other words, is FINRA already deciding that, or could it decide before we issue an opinion in this case?
I mean, I don't think it would go back to FINRA on remand, Your Honor, until this court reaches a decision.
I understand you don't think it, but is there anything that prohibits that from happening, that FINRA could actually rule on that before we issue an opinion?
I mean, I'm not sure if I have off the top of my head anything from the statute, but I think, you know, this court is reviewing the commission's conclusion. The commission had remanded to FINRA.
The commission made a remand order
Yes.
to FINRA, and that's presumably ongoing. FINRA's doing work on the case.
No, Your Honor, that's not my understanding.
Well, is that the record? Is that in this record? It was remanded to FINRA to do work.
In the order that's before
Well,
this court on review,
And
yes.
so it's not, that's why it's not a final order, as I understand it, but you're equivocating on that.
I'm not equivocating on that. The remand order is not a final order, Your Honor. We are not equivocating on that. We
Well,
certainly
then
agree with
it's-
FINRA in
Then
that
it's in the
respect.
hands of FINRA to do what they were supposed to do,
I mean, the
to
commission.
finish. Which has to do with, sort of like Brady claims or kind of stuff, where they, spoliation of evidence. They're supposed to reconsider that.
Yes,
or
all of
do
that.
some more work on it.
All of that will be back before FINRA, and
Well,
FINRA
they-
could decide not to pursue the charges at all, yes.
And if they do it, and I assume they could come back to the SEC, and you all, maybe you can come up with a final order. But at this point, you don't have it final.
I certainly agree with respect to the portions of the commission order that remanded, yes. And again, we think the statutory bar is preclusive of petitioner's constitutional claims. Unless there's any further questions, I'll let my friend from FINRA.
Let's see what FINRA has to say about this. Thank you very much. Mr. White?
Good morning, Your Honors. And
No,
may it-
I'm sorry, I'm in the wrong case. Mr. Tarani,
Correct, thank you, Your
I'm
Honor.
sorry.
May it please the Court,
Yes, sir, good to have you with us, sir.
Amir Tehrani for FINRA. Petitioner's constitutional challenge to FINRA is both procedurally and substantively flawed. Petitioners are prematurely seeking judicial review in the absence of final agency action and without exhausting their administrative remedies, and they are advancing constitutional arguments that are foreclosed by the precedent of both the Supreme Court and this court. On the question of finality, there is not a final order here within the meaning of Section 78YA1. And I would point this court to its decision in Newport News Shipbuilding versus Director, which involved a limited remand analogous in every material way to the remand that the SEC issued here. In Newport News Shipbuilding, the Department of Labor Board of Benefits Review had determined that the employer was liable to the employee for benefits. It had calculated the amount of temporary disability benefits, but it had remanded to an ALJ for a determination of the amount of permanent disability benefits. The employer petitioned for review to this court, and this court held that the order was not final because there was more work to be done by the agency, even though the agency had definitively determined that the employer was liable for benefits and had calculated the amount of temporary disability benefits. The fact that there was more work to be done with respect to the amount of permanent disability benefits foreclosed the availability of judicial
You have to
review.
read a lot into Newport News shipbuilding case. Not a whole lot of reasoning in that case, the procurement case. So much of what you're articulating about it is, I guess we have to sort of pull it out of what we think the court was saying there, right?
Well, the facts of the case are clear from the opinion, Your Honor. The procedural,
I grant you that. There's not a lot of reasoning in that case. It's just a procurement case, straightforward, right to the end. Not a whole lot of filling in the blanks.
well, I think it's a straightforward issue, Your Honor, that doesn't require a lot of reasoning. The Longshoremen and Harbor Workers Compensation Act, like the Exchange Act here, required a final order. And there was not a final order there because there was more work to be done by the agency. There is more work to be done by FINRA here.
So what would be the problem, if any, for FINRA if we do consider that sanctions part of the order?
It's inefficient, Your Honor, for this court to proceed with this type of piecemeal review. This court asked about the Saliba case in the Ninth Circuit, and for the reasons that you identified, Judge Thacker, that case is distinguishable because there was an immediately effective bar on the petitioner in that case. The petitioner who was before the Ninth Circuit was subject to an order with immediate legal consequences and effect. That is not the case with respect to Mr. Black and Southeast Investment because they have no obligation to pay the fine imposed by FINRA and affirmed by the SEC until the termination of all proceedings in this matter. So that fine is not due.
So what does this mean? If we agree with you, then we just wait until you decide whether or not you're going to have some more sanctions? I mean,
Yes, Your Honor. You wait just as you do in the ordinary course
what
of...
if you just sit on the case for a while? What do we do with that?
Well, the petitioners here have filed a separate district court case raising these same constitutional challenges to FINRA. They are free to attempt to move forward with that case in the district court to the extent that they
Are those
have...
constitutional issues identical to what they're raising here?
Yes, Your Honor.
The
They're...
very same constitutional issues they're presenting here, they have presented to the district court in a complaint. And the status of that is that it's been stayed pending these appeals. So it's upside down. Normally, the district courts rule first and then we review, right? That's the principle of how these appeal courts set up. But here, they got it upside down, and they got us reviewing first with the district court proceedings having been stayed. Are you in those cases too, that case?
Yes, Your Honor.
And that's out there, that's pending, it's stayed, but it's pending in the Western District of North Carolina,
That's
right today.
That's exactly right. So to the extent that the petitioners are seeking a venue in which to press these constitutional arguments, it would be in the district court where they are raising the same appointments clause, the same non-delegation, and the same...
What are they asking the district court to say those are unconstitutional and they would plead that here? Or what would they, or plead that in the administrative proceeding, or do you know what? How they plan to handle that?
The petitioners are asking the district court to enjoin the
Injunction relief, declaratory and injunctive relief,
Exactly
Yeah.
right, Your Honor.
but it's been stayed.
It has been stayed pending this court's decision because the same issues of
And your position here is that we don't have any jurisdiction for anything.
That's correct, Your Honor,
Is that
because
correct? That's the FINRA position. And now, what's the distinction between the FINRA position and the SEC position?
the SEC believes, based on the Saliba case, that there is jurisdiction.
And that's the Ninth Circuit case.
Correct.
And
That-
that's, you say that's an outlier or just distinguishable?
I don't think it's an outlier. I
You
think it
don't
is.
think it's an outlier? All right, that's what I was getting at. You give them that much credit. It's not an outlier, it's just distinguishable.
It's distinguishable because the petitioners there were subject to the immediate legal consequences of the SEC order, which barred the petitioner from associating with FINRA members. Here, there are no ongoing immediate consequences of the SEC's decision because the petitioners are not obligated to pay the fine that the SEC upheld.
Unless we hear that, so if we hear that part of the order and affirm the order below, then they'd have to pay the sanctions now?
No, Your Honor. They do
They
not.
still would have to wait until everything is final,
Correct.
which is why we should perhaps wait until everything is final.
That's our position, Your Honor. It's FINRA's published policy that respondents in disciplinary proceedings are not required to pay fines until all review by the SEC and by a court is complete. And that would include
And-
further review
And
of.
that's the critical distinction between this case and Saliba, because that was immediately, in Saliba, that was an immediate bar from membership.
Exactly. There were immediate legal consequences for the petitioner in that case. The petitioners here have also failed to exhaust their administrative remedies. As has been discussed already this morning, there is no categorical exception to statutory exhaustion for constitutional arguments. This court made that clear in Ed Potter Cole versus Director, where the court refused to consider an appointments clause challenge to a Department of Labor.
Let me ask you, you are, it's pretty much understood you are a private entity, but you can impose a lifetime ban on investors. Why is that not something of a governmental function?
Because FINRA is a private entity functioning subordinately to the SEC. As this court said in Jones versus SEC in discussing FINRA's predecessor, the NASD, the SEC exercises pervasive oversight authority and has a veto power over NASD and FINRA disciplinary proceedings. Here, the SEC undertook de novo independent review, and that review worked from the petitioner's perspective. The SEC didn't simply rubber stamp what FINRA did. The SEC affirmed in part, and it remanded in part. There is a powerful arsenal of tools that the SEC can bring to bear with respect to FINRA disciplinary proceedings to the extent that FINRA deviates from its statutory obligations, including revoking FINRA's registration as a national securities association or removing FINRA board members and officers, all of which are hallmarks of the fact that FINRA functions subordinately to the government.
These cases don't move very fast, do they? When you look at the time frame here, I mean, the SEC took 4.5 years to do something here. FINRA takes a period of time. I'm trying to figure that out in terms of, I guess we call it judicial economy and getting things, getting to the bottom of it. What role do we play in moving these cases along? Because it may be 4.5 years before you might be before this court again, or something is resolved here.
Judge King, I see my time has expired. May I answer the
As
question?
long as you get questions, you answer them.
Thank
Okay?
you. Thank you, Your Honor. I think that's why the ongoing district court proceedings are important here, Your Honor. The petitioners, to the extent that they are concerned about the length of the FINRA proceedings or the length of the SEC's review, have the opportunity to press these constitutional arguments in the district court. And if there is any merit to those arguments, and we would submit that there is not, but if there is, then they have the opportunity to seek near-term relief from the district court.
All right, thank you.
Thank you, Your Honor.
Thank you very much, sir. Mr. Donar?
Thank you, Your Honor. 2 quick points. First, regarding exhaustion and finality. Axon would not have been decided the way it was if the court had given any credence to this exhaustion and finality arguments. The crux of Axon is that there is a here and now injury of being subjected to a non-Article 3 adjudication process where the challenge is to the constitutionality of that non-Article 3 adjudication process. That is exactly the situation here. Axon is merely confirmatory of the fact that there is simply no credence to be paid to these exhaustion and finality arguments that SEC and FINRA are making. And a wider point in relation to that comes from Loper-Bright. In a case called DC Circuit, in a case called PDK Laboratories in the DC Circuit, then Judge John Roberts wrote that you can't make litigation a ping-pong game. Then Judge Roberts' words, not mine. And that's exactly what SEC and FINRA are asking us to do, to ping-pong us back to FINRA, up through SEC, maybe back to this court, only to be told that we needed to exhaust or the SEC order is not final. That is not how litigation
Axon
functions.
help you? I was just thinking about you citing that case there. How does that help you? When it makes it very clear that when you as a litigant choose to use a statutory review mechanism, you're subject to exhaustion.
Well, so Axon stands for the proposition that the first available court gets to decide structural constitutional claims. And this is the first available court under the statutory scheme.
Axon says when litigants choose to use a statutory review mechanism such as 15 U.S., et cetera, they must still meet its strictures, including exhaustion requirements. That's the question I'm asking you, is how does that help you?
I'm saying Axon is confirmatory because my principal argument rests on Carr versus Saul, in which the Social Security claimant went through the administrative process, and the first available court under the statutory scheme at issue with the Social Security Administration was the Federal District Court. And the Social Security claimant raised the structural constitutional issue for the first time in front of the first available court, which was the District Court. This is the first available court in the statutory scheme at issue here.
You were so confident in that, why'd you bring that lawsuit out there in Western North Carolina?
Well, Your Honor, that lawsuit is stayed pending this court's decision. So
But you initiated it.
Correct.
Yeah.
And we would press the exact same arguments there. And talking about this ping-pong litigation, this piecemeal litigation, that piecemeal litigation helps nobody. I see my time has expired. May I finish? That piecemeal litigation does not help anybody because it wastes everybody's resources. We have to go back and re-argue this whole thing in front of a unconstitutionally structured litigation process. For those reasons.
You said, I just want to make it clear on the point. The language that I brought, I was looking at it here, and it's actually a DC Circuit case, but it's talking about the Axon case in terms of requirement. But the Carr case is still, I brought it up earlier, it is a judge-made exhaustion rule, not a statutory one. Isn't that a distinction?
That is not a distinction because Carr dealt with the statutory scheme at issue there. The other cases that we rely on, Freitag, is the same thing. The argument was raised for the first time in the Fifth Circuit. The Fifth Circuit decided the structural constitutional claim because there it was a statutory scheme that gave you the only option was to go to the Circuit Courts of Appeals. So we make the argument under Carr, Freitag, and PHH Corp under the DC Circuit. We ask that you vacate the SEC's decision in its entirety. Thank you.
Thank you very much, sir. We appreciate it. We'll come down and greet counsel And then I'm going to exercise my discretion and call for a brief break. In our second case, we have Manus versus the Department of Agriculture. Mr. Robbins? Good to have you with us, Mr. Robbins.
Thank you, Your Honor. May it please the court, Josh Robbins for plaintiff appellant Joe Manus. The U.S. Department of Agriculture's administrative adjudication process for Horse Protection Act claims is unconstitutionally structured in multiple ways. Its final decision maker issues unreviewable decisions but is not appointed by a principal officer. Its administrative law judges are unconstitutionally tenure protected, and it resolves common law claims without a jury outside of an Article III court. These constitutional violations are causing Mr. Manus an ongoing irreparable harm in his Horse Protection Act adjudication that is still underway. This adjudication must be enjoined to avoid further irreparable injury to Mr. Manus while his constitutional claims are heard in federal court. I'd like to focus on two.
You presented these constitutional claims to Judge Osteen?
That's correct, Your
To
Honor.
the district court?
That's correct. We filed a lawsuit under Axon in district court, raised all of these claims, and moved for a preliminary injunction. So we're here before this
Is
court.
there anything in here that's not a constitutional claim? You got any statutory claims or anything besides constitutional claim?
Just constitutional claims, Your Honor. We have the Appointments Clause claim, a removal claim, a Seventh Amendment claim, and an Article III claim.
And you said the proceedings before the USDA are still ongoing. You haven't gotten a decision yet?
That's correct, Your Honor. So the hearing occurred before the administrative law judge already. Post-hearing briefing has concluded. Mr. Manus is still awaiting a decision.
Post-hearing briefing has concluded?
That's correct,
So you
Your
want
Honor.
us to enjoin the district court from ruling?
We're seeking a preliminary injunction of the USDA proceeding.
And the posture of that proceeding is that it's been fully heard and briefed, and now you're waiting on the district court ruling?
No, Your Honor. So we filed a collateral challenge to the ongoing proceeding.
Okay,
So
all right. So the USDA proceeding has been briefed, and you're waiting on a decision?
we're waiting a decision from the ALJ, but of course there could still be an appeal to the judicial
Okay,
officer.
so you want us to enjoin the ALJ from deciding?
Correct.
And that's what you presented to Judge Osteen in the district court?
Yeah, we asked for a
The
preliminary.
very same thing?
Correct. Well, we asked for a
You're
preliminary.
saying Judge Osteen erred, but I thought you were just trying to, you were trying to enjoin the hearing. Get Judge Osteen to stop the hearing before the ALJ.
Well, in our complaint, we sought for an injunction of Mr. Manus's USDA adjudication as a whole. At the time of the PI hearing before Judge Osteen, what was immediately before Mr. Manus was the hearing before the ALJ. That created particular urgency.
So Judge Osteen, he denied the injunction?
Correct.
Was he denying your request for relief against the hearing, or was he denying everything that was going to go on before the Department of Agriculture?
I understood Judge Osteen, and I'm happy to check the
Well, I understood you're
order.
a lawyer, we weren't there. I mean, and we got his opinion.
Yes, Your Honor.
It reads like it's considering the injunction request against the
Hearing.
hearing.
Yes, Your Honor.
If I recall it correctly, and you know more about it than I do.
Yes, Your Honor. So at the time, the focus of the discussion was on the hearing, but our request was for a preliminary injunction of the entire USDA adjudication process against Mr. Manus.
So that's what you're at least, and for sure, that's what you want us to do.
Yes, Your Honor.
So is it fair to say you're trying to get us to do something that you didn't request to Judge Osteen?
No, Your Honor. I believe we asked in our complaint and in the PI.
In the
and in our-
complaint, but you say, what was before him was a motion for injunctive relief.
Yes, sir. Your Honor,
For
we
a
requested.
preliminary injunction.
That's correct, Your Honor. Of
And
the
he wrote
entire.
And he wrote an opinion about these legal issues and denied them all.
That's correct, Your Honor.
But, and they had to hear it, that what he didn't enjoin, but they have other but they haven't made a decision yet.
That's correct.
So you want us to enjoin the decision.
The request for an
You can't
injunction.
enjoin the hearing, it's already been held.
That's correct, Your Honor, but our request for an injunction was for an injunction of the entire USDA proceeding,
Well,
which
yeah,
continues.
you do say at JA 32 on page 2 of your motion that what you're asking for is an immediate stay of the USDA adjudication until this case is resolved. So that goes to your point about the full thing, meaning until it's resolved, until there's a decision.
Yep, yes, Your Honor.
And does Judge Osteen's opinion reflect that that's the way he understood it?
Your Honor, I would have to look to make sure that the wording is correct, but I believe that Judge Osteen's, and I will confirm before I come back up for the reply, but our request for relief was for an injunction of the entire USDA adjudication process, and that's what Judge Osteen was ruling on. Thank you. So the first constitutional issue that I would like to address is our Seventh Amendment and Article 3 claims. The Supreme Court's decision this past June in SEC versus Jarkissi that common law securities fraud claims must be tried to a jury in an Article 3 court effectively decides that Mr. Maness is also entitled to a jury in an Article 3 court. Jarkissi applied a two-part test for the Seventh Amendment that has been longstanding. First, that the claim is common law in nature, that's a legal claim as opposed to one in equity or in admiralty. And second, whether or not that claim falls within the public rights
Did you say this
exception.
was a common law claim?
That's correct, Your Honor. The HPA claim is a common law claim.
What kind of claim?
Under Tull versus the United States, it's an action in debt. So in Tull, the Supreme Court recognized,
Action in debt?
that's correct, Your Honor.
Debt's historically one of those common law claims. They teach you common law pleading in your law school?
Did
you have common law pleading? You have a course in common law pleading?
No, Your Honor.
I had one. When I went, we had one. And yeah, I remember debt. Yeah, assumption, trespass on the case, things like that.
Yep.
Yeah, we had to know common law pleading. That helps when you get into these constitutional questions where they resurrect these things.
Yes, Your Honor. And in Tull,
But it also says $20 in that Seventh Amendment.
That-
Has to be a $20 claim, of 20, at least $20.
yes, Your Honor, and we believe that.
But I've read here that they've, one of the 28J letters, say they've changed the claim to $10.
Well, the APHIS has requested.
But they changed it to $10 on you.
They changed their request to, APHIS changed their request for only a $10 penalty, but under the statutory scheme, it's the ALJ and the judicial officer that has the ability to impose penalties, in this case, up to nearly $7,000. And in any event, under the voluntary cessation exception to the mootness doctrine, in its motion, the USDA maintains the ability to continue to impose penalties higher than $20. So Mr. Maness's Seventh
Now, you
Amendment
want
claim.
us to decide all four, as you got four constitutional claims?
Yes, Your Honor.
You want us to decide all four of them?
Well, you only need to decide one to enjoin the.
So that's what I mean. You think you only need to decide one of them?
That's correct, Your
Well,
Honor.
which one do you want us to decide?
Well, Your Honor, we think we're correct on all four, but
Well-
our preference would be,
You ever heard of Ashwander?
no, Your Honor.
That's disappointing. That's a Supreme Court case that says there's a thing called the constitutional avoidance doctrine. And courts aren't supposed to rule on constitutional issues if they can possibly rule on non-constitutional issues. And which would apply certainly to not deciding four constitutional issues if you can get away with only deciding one.
Well, Your Honor, this court.
But the Ashwander.
Well, Your Honor, this court could certainly decide the Seventh Amendment and/or Article 3 claims, and that would resolve the case and end the adjudication, because then
The 10th Amendment?
Seventh Amendment
The
and Article
7th Amendment. So you want to stick with the 7th Amendment?
I think the Seventh Amendment and Article 3 claims rise and fall together because of the structure of the
Well, now you want us to get
analysis.
two. You're down to two.
Well,
Two constitutional issues.
if you decide the Seventh Amendment, nested within it is the application of the public rights
So
exception.
which of the two you giving up?
I don't believe we can give up either of the claims in this case. Either, apologize, Your Honor, may I
You
finish?
don't want to give up any of the four. So you still maintain four claims
That's correct,
for
Your Honor.
violation of the Constitution by Judge Osteen's opinion.
We maintain all four claims, but of course, the court could grant a preliminary injunction based on any of the one. And my only explanation
You
is
want us to grant a permanent injunction,
just a preliminary injunction, Your
just
Honor.
just a preliminary injunction.
That's correct, Your Honor. This is up on a preliminary injunction, and any preliminary injunction would be short-lived in this case because summary judgment
Now,
is
the part
already.
about the Supreme Court case, the $20 thing, was that, had that been decided when Judge Osteen ruled?
No, Your Honor. Judge
So
Jarkissi,
there's a new case by the Supreme Court that you're arguing about that wasn't presented to the district court judge.
that's correct. Jarkissi wasn't decided until briefing was complete
Well,
in this case.
That wouldn't be very fair to him, for us to reverse him on that, would it?
Well, Your Honor, the case didn't come down until the day after briefing was complete. In this case, we filed a 28J letter of
I
supplemental
know you're
authority.
advising
and-
us of it, I'm not complaining about that, I'm just saying, if Judge Osteen didn't have that before him, the $20 claim on debt, with a $10 amendment.
Well, Your Honor, I believe this court nevertheless can decide the issue. And particularly, it's necessary in this preliminary injunction posture because our client, Mr. Manus, is being injured every day. He continues to be subject to the unconstitutionally structured adjudication.
Is Atlas roofing still good law in light of Jaworski?
In light of Jarkissi?
Yes.
I believe it's been extremely narrowed. So the court in that case, in its public rights analysis, said that the public rights exception had to be historically based, that it had to that there was a presumption that common law claims.
And you maintain that right here is one that's not a public right.
That's correct, Your Honor, because it's
But when
this.
we're talking about the soreness of animals, and in this instance, hobbling horses is probably the way I put it. You call it soreness, but hobbling an animal so that it would have a gait like a Tennessee walking horse that you could do naturally through other ways. And this act is here. Isn't that animal welfare? Can you even conceive of common law having a concern about animal welfare? I don't seem to, it doesn't seem to fit.
Well,
Like
two
that's more of a public right.
two responses to that, Your Honor. First, I think it's important how Congress structured the claim. So and the prohibition. So the statutory prohibition is not on soaring a horse. The statutory prohibition that Mr. Manus has been accused of here is allowing a horse that he owns to be entered into a competition while sore. And under 15 U.S.C. 1822, Congress said that it was enacting this statute to prevent unfairness in competition. And Congress also provided for punitive civil money penalties. So that sets up this case as a common law
But the
action.
point being, the competition brings the individuals, but they also said it was animal welfare. Doesn't that make it a public concern there?
I don't think the fact that the Congress also found an animal welfare concern changes the structure of
They made
the.
it strict liability.
That's correct, Your Honor. But under Tull, both the cause of action and the claim, the punitive civil monetary penalties, satisfies the common law nature of the claim as an action in debt. And I think this is very different than the OSH Act claims that were at issue in Atlas Roofing. Under the Occupational Safety and Health Act, Congress directed OSHA to come up with innovative ways to prevent workplace safety. Jarkissi described it as a building code, the regulations that OSHA came up with. And even the enforcement scheme itself is different. So you actually have inspectors going out to sites that issue citations that then people who receive the citations can challenge later. Here in this structure, you have a statutory prohibition on conduct with punitive civil monetary penalties. The horse is disqualified at the time, but the complaint isn't filed until later, so it looks very much like a court proceeding and easily falls within jargocy. I see my time has expired.
Thank you very much. Can you save some time?
Thank you.
Mr. White? You represent the Department of Agriculture?
I do.
Good to have you with us, sir.
Thank you, Your Honor. And may it please the court, Graham White for the Department of Agriculture. The district court committed no abuse of discretion here when it denied a preliminary injunction and instead allowed this case to proceed in the normal course. The district court correctly found that plaintiff is unlikely to succeed on the merits, but even apart from that, the plaintiff cannot show that he suffered an irreparable harm here or that the equities tip in his favor. And plaintiff's failure to establish any one of these factors is enough to affirm the denial of a preliminary injunction here. On the merits, I'll just start briefly with the Seventh Amendment issue since there was a little bit of back and forth there. There's no need for this court to reach the Seventh Amendment issue because, as we explained in our 28J letter, the agency has moved to amend its complaint and is no longer seeking a civil penalty in excess of $20. The Seventh Amendment, on its plain face, only applies to civil penalties in excess of $20.
Does it matter that ultimately there could be an award in excess of $20,000, I guess up to $6,000? Does that matter?
No, I don't think so for a couple of reasons.
Well, answer the first question then. Could there be an award in excess of $20,000, notwithstanding the SEC's demand or whatever for $20?
The ALJ has the discretion to issue an award within those confines of the statute.
So he could give more than 20.
But it's exceedingly unlikely for that to happen because the agency.
The question is, does it exceed $20 for the Constitution? The Constitution is pretty strict in terms of how you look at it. There's $20 in there. $20 back in then probably was a lot of money. It's no money now, but nonetheless, it's there. And, at least from the other perspective, they argue that because he could get up to $6,000, the SEC's demand for 20, it really might be, I guess, not feckless, but not effective.
Right, so a couple of responses, Judge Wynn. First, again, the agency has already said, with respect to the proceeding before the ALJ, it is no longer seeking $20. And I can represent to the court that the agency will not seek more than $20 throughout the administrative proceedings below.
Does the ALJ derive authority
From the statute. The statute gives the ALJ the authority to seek to implement a civil penalty. But the amount in controversy under the
Seventh. I mean, the ultimate creation, the ALJs, their existence, does it come from the SEC or as a delegation of authority, or how does that work?
So the ALJs are created by statute, and their authorities are they're required to follow the procedures that the secretary delegates here. But I think that's sort of beside the point from the Seventh Amendment inquiry. Again, as Judge King pointed out, there's no need for this court to reach the weighty constitutional issues on the Seventh Amendment problem. And let me just make one quick additional point. My friend on the other side mentioned the voluntary cessation exception to mootness. To the extent that he is suggesting that USDA could seek more than $20 in other cases going forward, plaintiff does not have standing to challenge USDA's levying of civil penalties in other cases. The voluntary cessation exception to mootness requires the plaintiff to show that he will again be subjected to the alleged illegality. And as I said a moment ago, the USDA has not only disclaimed any civil penalties in this case in excess of $20, it will not seek those penalties going forward in this proceeding. Now, as for the plaintiff's remaining merits arguments, plaintiff makes the argument that the judicial officer is a principal officer. The test for distinguishing principal officers from inferior officers under the Constitution is the three-factor test.
It's kind of a misnomer, though, isn't it?
I'm sorry?
That's a misnomer. They call it, a judicial officer is a title.
It's a title.
I think, but he's really an agency employee.
That's correct.
He's not a judicial officer.
Well, the judicial officer.
It's a misnomer. I'm trying to help you.
Well, I think.
It's a
yeah.
misnomer. Why they call him a judicial officer when it's not, he's not in Article 3? He's an employee of the Department of Agriculture.
That's exactly right. The judicial officer's authority, he exercises
He's
only.
not a judicial officer.
Well, sorry, I'm just,
So it's
for
a
lack of
misnomer.
for lack of a better term, Judge King, I'll just refer to him because that's the title that the secretary delegated to him. But to your point, the judicial officer exercises only the authority delegated to him by the secretary. Okay, and under the three-factor test in Edmund, none of the factors are dispositive, and courts are required to consider the degree of administrative oversight by the secretary, removal authority, and final decision-making authority. And those three factors point decisively in favor of inferior officer status for this particular employee. Because as we explained in our brief, the judicial officer is solely a creature of regulation. He only exercises the authority that the secretary delegates to him. The secretary can rescind that delegation of authority at any time. And the USDA's regulations expressly state that nothing.
Once a judicial officer makes a determination, can the secretary review it?
No, but that factor is not dispositive under the Supreme Court's decision in Arthrex. It's a three-factor test, and we know it's not dispositive because the Supreme Court in Arthrex cited with approval other examples of inferior officers throughout the government who exercise final decision-making authority, but are still accountable to a principal officer in other ways. The Benefits Review Board at the Department of Labor is one example that we cite in our brief and the Supreme Court discusses in Arthrex. There are other examples here. But one other critical point, Judge Wynn, there is that even if the judicial officer, or excuse me, even if the Secretary of Agriculture can't review a decision retroactively from the judicial officer, the Secretary is still accountable for that decision. And that's a critical point because the Supreme Court in Arthrex made clear that the fundamental concern under the Appointments Clause is about accountability. Is there a chain of accountability running from the inferior officer all the way up through the department head and other principal officers within the department? So in Arthrex, that was not satisfied because Congress essentially forced a particular system of administrative adjudication on the agency. All right, the PTO director had no authority, had very limited authority by statute to issue procedures governing the patent proceedings. He couldn't remove the officer and couldn't review the final decisions. That's not what we have here because the Secretary of Agriculture can modify any of the judicial officer's powers, including final decision-making authority at any time.
In reviewing this, I couldn't help but think about my military days as a military judge and how the military courts work, and there's such a thing called a convening authority. You go through the whole process and they can undo it all. You don't quite have that here because, as you say, it's not reviewable, but nonetheless, that judicial officer is accountable. And I'm really having a hard time figuring out how is he accountable? I mean, in what way?
Because the buck ultimately stops with the secretary. If the judicial officer makes a decision that is unpopular or sparks any kind of political backlash, the blame still lies with the secretary because he is the one who created the judicial officer and delegated him powers. That is not what was true in Arthrex because Congress essentially insulated the Patent Trial and Appeal Board completely from supervision.
But that's kind of my point. He's the one that has all the authority to give it to him. But once he makes that decision, it's not retroactive. He can't review it. And it seems like, that sounds like he's a principal officer to me.
No, but again, Judge Wynn, under Edmund, that is only one factor, and it's not dispositive. We know, again, that that is not a dispositive factor because the Supreme Court, as I mentioned a moment ago, in Arthrex, cited to other examples where inferior officers permissibly exercise final decision-making authority. But even if Your Honor were to disagree with that, I just want to talk about the remedy for a second. Plaintiff is seeking to enjoin the entire administrative proceeding here. That is not what the Supreme Court held.
Right, let me ask you about that. Opposing counsel says that the USDA proceeding has been completed and fully briefed and only now waiting on the ALJ decision. Is that correct?
That is correct, Your Honor.
If the ALJ decides this afternoon, is this appeal moot?
Well, I mean, I think it's already, it probably depends on the claim, because, I mean, the Seventh Amendment claim is moot because the USDA isn't seeking penalties. I mean, I think, as my friend on the other side said a moment ago, they're challenging the entire adjudicative process going up. I mean, I guess it would.
But the appeal is only for, what else, after the ALJ, what other adjudicative process is there?
Sorry, so there could be an appeal of the decision to the judicial officer, and I think sort of the hypothetical nature of your question sort of underscores why relief is inappropriate at this stage, because look, we don't even have a decision from the from the ALJ. That might be helpful in resolving some of the plaintiff's claims here, including the Seventh Amendment claim, where he asserts that he's going to be on the hook for for civil penalties in excess of $20. I think that's very unlikely to be the case. We'll find out when the ALJ issues its decision. Now,
You would be okay with following Judge Thacker's position for this to be moved?
of course. Look, I mean, I think there's no, ultimately, we're in the posture of a preliminary injunction.
Were you involved in the proceedings in the district court?
No, I was not.
Well, who represented the agriculture department there? The United States Attorney?
Yes.
And you all didn't work with, you're in the civil division of the Department of Justice.
On the appellate staff, so.
Pardon?
On the appellate staff, so we were brought in to handle this case on appeal
So,
in this court.
okay. So you weren't in the lower court. Do you know, was this case argued before Judge Osteen?
There was a hearing, yes.
Pardon?
Yes, there was a hearing.
There was a hearing before Judge Osteen.
Yeah.
And he wrote an opinion,
That's correct.
and he denied a temporary restraining order and a preliminary injunction.
That's correct, in two separate opinions.
And he only ruled on one element of the preliminary injunction test.
That's correct.
That was the likelihood of success on the merits. There are four. So what possible, then they appealed. So what, and all they were asking for, they told him, I think, was to stop the hearing. Well, he claims that that's motion or the complaint said something broader than that. What's really on appeal here with, from Judge Osteen?
So, I mean,
They say there are four constitutional questions,
right. So I understand.
and they want to decide them all. And the only question was, before Judge Osteen ruled on, was the likelihood of success. Likelihood, not the fact that they were going to succeed, but the likelihood of success. Because he's on a preliminary injunction.
That's right. So
And he denied it.
he denied it. The fundamental question here is whether that denial was an
So
abuse
what
of
can you
discretion.
appeal after somebody denies a preliminary injunction?
Why?
Appeal everything? The possible, you appeal four constitutional issues that were never ruled on?
Well, plaintiff is arguing that the district court abused its discretion. We obviously disagree with that. But to Your Honor's point, the likelihood of success on the merits is only one factor here. And this court can affirm the denial of a preliminary injunction for the failure to show any of the other factors, including irreparable harm here. Because again, the plaintiff has not put forward any evidence or any argument that he has suffered an irreparable injury other than having to participate in this agency proceeding. And he asserts that's enough under Axon, but that is not what Axon
Well,
said.
what do you want us to do here? What would you have us do? Affirm Judge Osteen?
Yes, this court should affirm
Or
the
dismiss the case?
this court should affirm the denial of the preliminary injunction.
Affirm it. You want it affirmed.
That's
Okay.
correct. And so again,
So you don't take position that any of it's moot?
well, the Seventh Amendment claim is moot because we're not
Well,
wrong.
I'm asking you what you want us to do.
Yes, this court can affirm the denial of a preliminary injunction.
We can, but what do you want us to do?
There are a number of avenues here. You could either say that there's no irreparable harm. That's probably the most straightforward way, because under Axon had nothing to do with the standard for a preliminary injunction. This court's sister circuits have already held that, the D.C. Circuit in Albine Securities, the 10th Circuit in Leachco. So just on irreparable harm, that's probably the most straightforward way for this court to affirm the denial of a preliminary injunction. There's no need to necessarily address any of the merits issues here. And again, on the irreparable harm issue, plaintiff would have to satisfy it, and he's asking this court to come into conflict with the D.C. Circuit and the 10th Circuit. And I believe the 6th Circuit, albeit in an unpublished opinion, also rejected the plaintiff's interpretation of Axon as speaking to the irreparable harm factor on a preliminary injunction. Unless the court has other questions
Is
about...
it relevant here that this Supreme Court case that's about the $20 in the Seventh Amendment wasn't decided until after Judge Osteen ruled?
Well, I think it underscores that the district court did not abuse its discretion at the time because the court was assessing the likelihood of success at the merits at the time it heard the case. Jarkissi had not been decided at that point. I think authority pointed pretty decisively in favor of showing that plaintiff was unlikely to succeed on his Seventh Amendment claims. And so I think the fact that Jarkissi was decided after the fact does show that there was no abuse of discretion here. Now, unless the court has any other questions on that, I'll run through some of the other merits arguments since there are 4 total constitutional challenges here. The plaintiff also makes an argument that the ALJ's removal restrictions are unconstitutional. This court can easily dispense with that argument because under K&R contractors, it made clear that the plaintiff is not entitled to relief on that claim because the actions of a lawfully appointed officer are legitimate and enforceable even if...
Can we rest this on solely the question of whether the exception applies?
I'm sorry, I didn't catch that.
The exception of whether it is a public right or a private right?
I'm sorry.
In other words, the
Sorry, I couldn't hear you.
exception to whether this is considered a part of the Seventh Amendment, Article 3, as to whether it is a public right or a private right that's being implicated here.
Right, so I think the merits of the Seventh Amendment claim would implicate that distinction. And I would just say, though, if this court is seriously considering ruling on the merits on that particular issue, and again, I think for reasons we've discussed, there's no need
But
to.
could we rest it solely on that if we determine one way or the other that it meets that requirement?
Yes, if this court finds that the Horse Protection Act claim involves public rights, then that should be dispositive of the Seventh Amendment
Well,
inquiry.
does it?
I'm sorry?
Does it implicate a public right?
I think it does, because look, this involves a question of, this is not the sort of claim that could have been brought at common law.
What if
I
it
think-
implicates both public and a private right? Then what does that leave us?
I mean, I'm not sure if, I think for something to implicate a public right, it has to be analogous to, for something to implicate a private right, it has to be analogous to a common law claim at minimum. Now, plaintiff has argued that this is analogous to a common law fraud claim, but that's just not accurate because the fundamental element of any common law fraud claim is a statement or an intent to mislead or deceive, and that's just not right. And that's not a requirement of a violation.
What about it seems like there's some part of it that says it's there to deal with the individuals involved in the process and animal welfare. So it seems like it has some aspects of both public and private.
So the primary purpose under the Horse Protection Act, and this is set forth in the first subsection of the statute addressing the congressional purpose and findings, is to prevent the abuse of these animals. A secondary subsidiary finding that Your Honor might be referring to is the regulation of competition here, but that subsidiary point doesn't require fraud or an intent to deceive, and that's a critical point here. The government's allegations in Mr. Manis don't allege that there was any fraud or deception here. It just alleges that he entered a horse that was sored into this competition. There's no fraud that's required here. To give Your Honor an example, someone can enter a sored horse into a competition. Everybody can know it's sored, so there's no fraud or deception.
Is that the whole purpose of strict liability?
I'm sorry?
That if it's strict liability, you don't have to go to prove those elements?
Well, I mean, that may be why Congress wrote the Horse Protection Act in this way, but there is no scienter requirement, and so it's not analogous to a common law fraud claim. There's just no reason for the court, for the court to draw an analogy to common law fraud. But I just want to reiterate, there's no need, again, for this court to address the issue. But, one point that I did want to make judgment on this before moving on to something else is that if this court does want to address the merits of this, thus far, after Jarkissi, all we've done is file supplemental letter briefs, 28J letters on this issue. A ruling on the Jarkissi issue, on the Seventh Amendment issue, would be enormously consequential for the federal government, and so we would, only if the court is seriously intending on ruling on this, respect the opportunity to file a supplemental brief addressing the scope of Jarkissi. Having said that, there are a number of avenues
My question is more, is it a case we could say, sometimes you don't have to get to the merits, you can say, assuming for the sake of argument, that then therefore, if that is so, the exception still does not provide relief here. Is that an avenue?
So is there a case about whether this particular statute fits within? I mean, I think the McConnell case out of the Sixth Circuit, albeit that was a district court decision, held that the actions brought under the Horse Protection Act do not implicate private rights, they implicate public rights. And so that's one example. And so again, I would just reiterate, there's no need for the court to go near this, but that would be one example of a case citing that.
So basically, you like Judge King's reference to Ashwanda that he brought up earlier on constitutional avoidance.
Constitutional avoidance, sure. But then again, that goes back to the posture that we're in.
You familiar with that case?
Well, I'm familiar with the canon of constitutional avoidance. And I'm also familiar with the posture in which this case is being raised, which does not require this court to necessarily rule on the merits, because again, there are 4 preliminary injunction factors here. Plaintiff can't establish irreparable harm. He can't show that the equities tip in his favor. And so just for that reason, under the preliminary injunction standard, there's no reason for this court to go near the merits, to say nothing of the constitutional avoidance canon. I think that is my point on that. So yes, again, with respect to the removal restriction, there's no need under K&R contractors for this court to go on that issue, because the plaintiff is not entitled to relief, because the ALJs were lawfully appointed. There's no dispute here, and so plaintiff isn't entitled to relief on that claim. The plaintiff's argument that the judicial officer has to hold an office created by statute is contrary to the plain text of the Appointments Clause. All that requires is for Congress to vest by law the appointment of inferior officers and department heads. It has done so with 7 U.S.C. subsection 2204-2. It's a broad grant of authority to the secretary to delegate his authorities and also to create appropriate titles. The plain text of the statute presupposes that the secretary will create the titles and the offices. And so, unless the court has any other questions on the merits, we would ask to affirm.
Thank you very much, Mr. White. Mr. Robbins?
Thank you, Your Honor. Just to briefly set the procedural table, Your Honor, Judge King was asking what we requested in the lower court. And our motion requested for an injunction against the USDA from pursuing an alleged violation of the Horse Protection Act against Mr. Manus in USDA's unconstitutional adjudication process, and we cited to the docket number for the adjudication. And then in his opinion, he characterized our request as a request for being enjoined from enforcing the Horse Protection Act against plaintiff through the USDA's administrative adjudication process. So the entire adjudication process for Mr. Manus will continue through the judicial officer's ultimate decision if there is an appeal, which is at some unknowable point in the future. So Mr. Manus has availed himself under Axon the opportunity to bring a collateral challenge to the claim, to the adjudication, raising his constitutional claims as it's ongoing, as the Supreme Court recognized that he could. And given that the injury that was recognized in Axon is being subjected to an unconstitutionally structured adjudication, he is suffering that injury each day he is in the adjudication. And so he sought a preliminary injunction of the entire adjudication process. Now, it's correct, Judge Osteen denied that preliminary injunction. He ruled only on the first factor, that Mr. Manus was unlikely to succeed on the merits of his
What is the irreparable harm?
Here, it is any one of the constitutional violations. So this court has recognized in the Miranda and the Leaders of a Beautiful Struggle cases that a deprivation of constitutional rights or a constitutional violation is necessarily an irreparable injury, even if it occurs for a minimal period of time. So I think if you combine Axon and Fourth Circuit precedent as distinct from DC Circuit precedent, this court, if this court finds that there's a likely constitutional violation on any one of the 4 claims, Mr. Manus has satisfied the irreparable injury prong and the public interest prong as well, because this court and the Supreme Court have recognized that the government has no interest in pursuing policies, even desirable policies, through unconstitutional means. As to the Appointments Clause claim, I think that the Department of Agriculture's concession that the judicial officer's decisions cannot be reviewed by the Secretary is a concession that ends the Appointments Clause claim in Mr. Manus's favor. After Arthrex, executive branch adjudicators have to have their decisions reviewed by principal officers in order for them to be inferior officers. There's no dispute here that the judicial officer is at most is not a principal officer. He's not appointed by the president or confirmed by the Senate. And the structure of the Arthrex opinion was
What about remedy? Even if he is inappropriately appointed as a judicial officer, why would the remedy be to stop the proceeding before the ALJ?
Well, Your Honor, what we're seeking here is a preliminary injunction, which I think is distinct from the final remedy in the case. And the USDA has made no argument in its briefing or in the lower court that the nature of the final remedy would have an impact on whether the current adjudication process
Even if
can
we
go
agree
forward.
with you, you would say the proceeding before the ALJ does not stop.
No, the entire proceeding, including before the ALJ, has to stop, because if the USDA is correct that the judicial officer is properly functioning as an inferior officer, then the ALJs themselves are improperly supervised, because there's no principal officer to review their decisions. The secretary can't intervene, he can't revoke the judicial officer's delegation, which would be the mechanism to review an ALJ decision without raising serious constitutional due process concerns under the Utica packing case out of the Sixth Circuit. There, the secretary replaced the judicial officer after his initial decision and issued a subsequent decision, and that court found that to be unconstitutional because it was an unacceptable risk of unfairness to have a.
So what is the remedy? Severability?
Well, the remedy today would be to preliminarily enjoin the adjudication while the merits of the adjudication are heard in the district court. So the district court case has not been stayed. Summary judgment has been fully briefed and is pending before Judge Osteen. All Mr.
The
Manus is
summary
asking.
judgment motion is pending.
That's correct, Your
So
Honor.
he could rule in your favor before we rule.
That's conceivably possible, Your Honor, but Mr. Manus is still Mr. Manus is still being injured every
Have
day.
you argued that motion?
No, Your Honor. I see
So
my
you just want, you want us to change things while it's still pending before Judge Osteen.
Your Honor, we believe that Mr. Manus is suffering this irreparable injury every day, and we've taken
Mr.
every.
Manus is suffering, but I thought you're worried about the horse.
At the preliminary injunction stage, he's being injured by being subjected to this unconstitutional process.
And you say he's suffering 4 constitutional violations
That's correct, Your Honor.
every day.
While the USDA adjudication is ongoing, correct, through the final decision of the judicial officer. No further
Thank you very
questions.
much.
Thank you, Your Honor.
We'll take a matter under advisement. We'll come down and greet counsel, and then we'll proceed to the final case. We're Solis versus Amadeus, North Carolina. Mr. Bynes,
That's correct, Your Honor.
good to have you with us, Mr. Bynes.
Thank you, Your Honor. May it please the court, John Bynes on behalf of the appellant. The central issue before the court is whether this action, or the action that was pending in the Eastern District, the Rosales action, is barred by the first to file rule because of a prior action filed in the District of South Carolina called the Byers action. The first to file rule, as you know, is contained within the False Claims Act. The issue is whether this action is a, quote, related action to the buyer's action. And to address that issue, I would like to hit 3 points. One, talk about the standard and the application of the standard to this case. Two, look at which complaints are supposed to be compared to determine whether or not the Rosales action is a related action to the buyer's action. And then number three, address whether this court should look at the motion to dismiss as a 12B1 subject matter jurisdiction motion to dismiss as the court ruled below, or a 12B6 motion for failure to state a claim. The standard that has been developed in this circuit and many others is the same material elements test. And that simply means, well, we actually know from a few cases in this court what it means in a very limited sense, and that's the Carson case and the Carter case. We know that very slight differences between case A and case B are not sufficient to defeat the first to file rule. We know that from those two cases. But our point in this appeal and our point before the district court was that in this case, we have three defendants that are not in the buyer's action. And what does that mean? That means even if buyers wins everything they claim, everything they allege, go to trial and win everything you could possibly win, they will not recover one dime for the United States of America against the three appellees in this case, the three defendants below.
Is the identity of the defendants alone sufficient to defeat the first to file rule?
I'm sorry, I missed the first part of your question, Your Honor.
Is the identity of the defendants alone sufficient to defeat the first to file rule?
When you say alone, in this case, yes. In every case, I'm not sure I could say that because there's so many different fact patterns that could develop.
Why here?
Because a
The
subsidiary,
buyer's claim included medical officer, and as I understand, the defendant here is just that, a medical officer,
well,
although
I
not
mean,
the precise one,
you
I
have
presume.
Corporation A and some of their related entities in South Carolina are defendants. Here you have Corporation B, C, and individual D. None of the defendants that remain in the Rosales case exist or have ever existed in the buyer's case. And so we have a situation
So
where
you do have Corporation A, B, C, but you have over all of them the parent corporation. The buyers did implicate the parent corporation in South Carolina.
that's correct. And if this case were only against the parent corporation, I would agree that this case would be barred by the first to file rule, right? Because if you compare the claims, meaning the...
Okay, I need some explanation on that. You're saying if it was only the parent, then it's included. But the fact that they included the subsidiary along with the parent, the answer is no, it doesn't meet it?
Correct. And the reason is simply because subsidiaries are separate entities. That's why defendants go through all the trouble of setting up all these different entities all over the country so that they can preserve any liability so it doesn't shoot through to the parent corporation. That's the whole point of setting them up in that fashion. In fact, if you look at the Carson case, you see that played out in that case, and that the two complaints that were competing to determine whether or not the second was barred by the first to file rule, they were determining whether ManorCare, the parent corporation, and 4 pages of subsidiaries. And I suspect what happened, I haven't looked at the complaints, but I bet ManorCare went ahead and created a separate subsidiary for every one of its entities all over, every one of its locations all over the country. And that's why you had so many subsidiaries in that case, right? But in that case, because the subsidiaries were defendants in both cases, the court found that the second case was barred by the first case, right? And so just from 1,000 feet, you can't have case 1 defeat case 2 under the first to file rule when case 1 doesn't have the same defendants as the second case, in this case. We also have
Well,
an additional...
without appellant's complaint in this case, could the government still pursue action against Emetitus and Dr. Batiste under the buyer's complaint?
Well, they could in every case, but in this case, they declined to do it in either case, right? And so that's always an issue, and that's addressed in some of the cases that talk about giving the government enough information to investigate the fraud and to decide whether or not to intervene in the case.
Doesn't the fact that they could have in either case sort of defeat your argument?
Well, no, Your Honor, there's nothing in the buyer's action that puts, assuming that's the standard, I think the case law confuses legal standard with an explanation as to why the legal standard exists, right? And so this whole idea that the government has some kind of notice that would allow them to investigate and decline or not decline to intervene in the case, that notice is trying to explain the underpinning of the first to file rule, but it doesn't really get at the problem in this case. The problem in this case has nothing to do with the government because the government declined in both cases, okay? And
Can the
so
government change its mind?
they can. The Supreme Court says they
They've
can,
done that.
but they haven't.
Right, they haven't,
Yes.
historically, they've done it time to time.
Historically, they very rarely, I'm not an expert in False Claims Act cases, I should say, but from
They
what
very
I've...
rarely do it, I'll agree with that. It's key, Tom, it's what we used to call them the private attorney general suits. I was in the government for a while,
You still are.
and dealt with some of them. I mean, the executive branch.
Yeah, okay.
Well, again, I mean, talking about materiality,
And we
that's-
see them up here, that's right. Yeah, we see them here. Everybody's trying to help out, to keep the fraud out of these things. It's the False Claims Act.
that's correct, Your Honor. It has a
The
worthy...
private attorneys general bring these things, and they're like bounty hunters. Out west,
In effect, and it goes back to the 1860s. That's exactly the system they set up. Incentivize private citizens to go
that's what,
root out fraud.
we used to call them that too.
So, when we talk about...
Let's clarify at least
Yeah.
a point from my perspective, and that is that you speak as to whether the government has an option to intervene. When it seems to me, the question really is, does the government have notice of an opportunity? In this instance, why isn't it that the government, by the buyer's complaint, is not given notice upon which it can make a decision as to whether to move against the North Carolina entity or even Dr. Batiste?
Well, I think that also gets us to the place that I want to take this court, and that is if you start with the proposition that this is really just kind of a notice exercise, that we want to give the government adequate notice so they can intervene or not intervene, if you follow that line of reasoning, which I don't think you should for a number of reasons, put in my brief and my reply brief, but if you follow that reasoning, there's nothing in the buyer's action, for instance, that says, hey, there's this doctor in North Carolina that is cheating the government, and he's working with the North Carolina subsidiary of Emetitus to do so, right? There's nothing about that South Carolina case that would put the government on notice to investigate in North Carolina.
But you do have the parent corporation in the South Carolina case.
I'm sorry, say it
The
again?
parent corporation is involved in the South Carolina cases,
The
right?
parent corporation is,
Why
although...
would that not put you on notice to look at the subsidiaries and those who are part of the parent corporation, at least the government?
Well, again, if you're talking about notice, yes, I guess if you know one nugget of fraud in somewhere in America, then arguably that pebble creates ripples that go endlessly in every direction. I don't think that's the appropriate way to look at these cases. And it goes back to the actual language in the first to file rule. It simply focuses on what's related mean. A related action is barred, an unrelated action is not barred. What does that mean? Well, it means you have to apply a test. this court has applied the test.
But
called the-
fundamentally, isn't that what this is about, as Judge King alluded to? This is private actions. You get the government involved because the statute says the government is the one that can get involved. I suppose ostensibly it comes up because the government doesn't know about this. That's why the notice thing keep coming up. But it's just a question of whether or not they know there's an alleged fraud out there. Because the government otherwise wouldn't know it unless you bring an action like this. They bring it and it says, okay, government, here, look, you're not looking. And once they get this indication to look, you're looking at the parent corporation. And I understand the difficulty because these things are filed on a seal. So who knows? When you file them, you don't know what's been filed. But nonetheless, it's there against the parent corporation. So if the inquiry is whether the government is being given an opportunity to know, being noticed or whatever on an alleged fraud of the parent corporation, why wouldn't that implicate North Carolina and Dr. Batiste and anybody else who's a part of that parent corporation?
Well, again, the best analogy I can come up with, and I'll use it again, is the pebble in the lake. Yes, there are ripples at some point that stop. The rubber band gets stretched to the point of snapping. And if someone puts the government on notice of a fraud, even against their parent corporation, who's headquartered in Louisiana, but does that in Alaska, they're cheating the government in Alaska. Your Honor, please, or federal government, please take a look at this and investigate. You would be saying that once the government has notice of that, then unless they find all the fraud that exists in America that relates to that same sort of scheme, including, as in this case, the doctors that assisted in the illegal scheme, that somehow the first to file rule would bar the second filed case that is bringing these additional items to the federal government's attention. In other words, there's nothing about the Byers case, getting back to the specifics of this case, there's nothing about that complaint that puts the government on notice of anything Dr. Batiste is doing in North Carolina.
Well, I mean, we can use terms like that, but I just want to make sure, at least in terms of how we think about this, do you disagree that at least I think from our court, the way we've looked at this is that the purpose here is to alert the government of this opportunity here. I mean, the notice aspect of it we can play with, but I'm just using an actual word. Notice, to alert the government of the fact that there is a fraud being committed.
And I think you said the pivotal word, purpose.
Do you disagree with that?
I agree that is a purpose, but it's not the pivotal purpose. The pivotal issue before the court in this case, and in all these cases, is case B a related action within the definition of the first to file rule that bars it from proceeding. And I see my time is almost up, so I won't get a chance on my other two issues, but I'll address them in my response. Thank you.
Very good, sir. Mr. French?
Morning. Excuse me. Good morning, Your Honor. May it please the court. I think what counsel was just describing essentially is advocating for the identical facts test, which I think almost every court that's addressed this issue has rejected. This court in Carson adopted the same material elements of fraud test, which does not require exact symmetry between every defendant and every claim. I'd also point out that I think this is the first in the closest that Ms. Rosales has come this morning to actually trying to distinguish the factual allegations in either her initial complaint or her amended complaint. Basically what she's relied on is, I filed this amended complaint that adds Dr. Badish and his practice, and then I voluntarily dismissed, after receiving our motion to dismiss, Amedisys Inc., the parent company, and 11 other subsidiaries. So now there's a difference in the defendants. That, as Judge Wynn was, I believe, getting at, the Byers case does allege allegations against Amedisys Inc. in a number of its subsidiaries. That also wasn't the only case that was pending at the time that Ms. Rosales filed her complaint. There was also a key TAM filed in West Virginia, and there was another key TAM filed in New York, both of which were also against Amedisys Inc.
let me ask you something that's, maybe it's more curious to me. If an action is brought and then the government then declines, it seems like to me that's a different posture than if the government takes it, because the government, by taking it, I can clearly see how the government can go against the parent corporation, all of the subsidiaries, but an individual who's only named that parent and that particular entity, seems like that's a pretty limited action there. And it does not reach into North Carolina and other areas. Is that something you follow, or how does that work?
Your Honor, what I would say is that the purpose, and numerous courts have reiterated this, the purpose of the first to file rule is to put the government on notice and to equip them to investigate fraud. What the district court said here was that the buyer's complaint alleged a company-wide fraudulent scheme, and in the district court's view, that would put the government on notice of what's going on in North Carolina. It's impossible in these cases, I think, to list every single potential fact that might come up. I think that's why the court has focused on the material elements of fraud test as opposed to some other test that's out there.
So how does that play out if this goes forward, buyers proceeds on, and let's assume remedy is obtained, is there then an opportunity to pursue a separate claim in a separate action that's not part of the first to file? In other words, does the first to file go away and you then can proceed against North Carolina on this?
I think what would happen, Your Honor, is that this court, and I think the district court, correctly dismissed the action because at the time the Rosales complaint was filed, there was and remains a pending case, a pending related case. This court in its Carter decisions has made very clear that the remedy in that situation is to dismiss without leave to amend, so that the relator, when and if buyers ever comes to a conclusion, Ms. Rosales can refile her claim at that time. That's an important distinction in what she's trying to do here, which is to essentially amend in the course of an existing action. So she's not without rights. They will have the right, as the court did here, we dismissed the case without prejudice, and then when and if buyers is no longer in existence, that bar, that jurisdictional or statutory bar, however we want to look at it, is no longer in place, and there's nothing then that prevents prevents Ms. Rosales from filing a claim.
Okay.
In anticipation of counsel indicated that they would like to address the jurisdictional issue, and I think one thing I would like to point out to the court is we don't think it's, first of all, we believe the court's made it very clear in several opinions that it considers the first to file rule to be jurisdictional. In the Carter case, the relator in that case raised the same issue of whether or not the first to file rule is jurisdictional. The court in that case acknowledged that there had been, at least at that point, two different circuit court cases that had gone back on their prior holdings and said, we don't believe that the case is jurisdictional anymore. Despite that, this court still held on to the view that we understand that those cases exist. However, we've spoken on that issue. Along those lines, I do want, in the purpose of candor, to alert the court to a case, Stein versus Kaiser Foundation, at 115 F 4th 1244. That's a case that came down since the briefing in this case. In that case, the Ninth Circuit basically followed some of the other circuits and overturned its prior precedent, saying that we think the rule is jurisdictional. The Ninth Circuit has now joined those other circuits in saying we think it's non-jurisdictional. That having been said, we think that this court has clearly spoken that it is jurisdictional. Having said that, we don't think it matters in that the court even has to address that issue. We moved to dismiss both on Rule 12b1 and 12b6 grounds. Under either test, the court applies the same material elements of fraud test, and that's what the district court did here. So there's, and this court also has the ability to affirm on a de novo review, to affirm on any grounds supported by the record, notwithstanding the reasoning of the district court. So even if this court were to change course and decide that the first to file bar is not jurisdictional, applying those same material elements test would, we think, lead to the same result. We already know what the district court's view on that issue is because the district court applied that test and came to the determination that, that the cases are related and that the Rosales action should be barred.
What's the significance? Judge Dever dismissed this case without prejudice. What's the significance of that?
With dismissing it without prejudice?
Yes.
Well, it preserves the relators. It preserves Ms. Rosales' right to come back afterwards once the procedural or jurisdictional bar is no longer there. In the Byers case, it allows for Ms. Rosales to file her complaint down the road. So when and if the Byers case no longer exists through settlement or dismissal, there's a pathway at that point for Ms. Rosales to refile her claim at that time. And that's the way that this court and pretty much every other court except the Gadbois case in the First Circuit have suggested the matter needs to be resolved. If there are no other questions. Thank you, Your Honor.
Thank you very much. Mr. Bond?
I'd like to address the issue of which complaints should the court have compared, and that is the original complaint in Byers and the amended complaint in Rosales. If you look at the motion to dismiss that was filed below, it was only the amended complaint that was attached to that motion. And yes, there was a reference to 12b1, just simply pursuant to 12b1 and 12b6. But then if you look at the content of the motion, it was all 12b6. So that was clearly where the motion was headed. But if you look at the trial court's ruling that Ms. Rosales was not allowed to amend her complaint, it runs up against a number of problems. One is it runs up against Rule 15, which says you can, in every instance, amend your complaint. In fact, that right has been described in the Galiustian case out of the circuit as an absolute right. So, it's an absolute right unless the False Claims Act somehow carves out an exception that makes no sense. Also, if you look at the reasoning behind the few courts that have tried to freeze the false claims plaintiff as of the moment of filing, what they're really doing is they're trying to draw an analogy between False Claims Act first to file issues and diversity jurisdiction. That's kind of the thrust of most of the cases. And the idea being that, yes, unless there's diversity on the day that you file the complaint, you can't fix that at a later date. But that's a fact. That's not an allegation or a pleading defect that could be corrected. A pleading defect can be corrected, but a fact that exists cannot be corrected. If you didn't live in a separate state, if there wasn't complete diversity on the moment that you filed the lawsuit, you can't move into another state 3 days later and try to create diversity. So I think they've taken a square peg in a round hole, but that's the minority view. As you're seeing in other cases, it's the amended, the plaintiff has the right to amend the complaint. They're not frozen in time. Rule 15 applies, and it should apply, and this court has already said that that right is absolute. The next issue is the jurisdictional issue. Now, that one is trickier, admittedly. And the reason is because both Carter and Carson suggest that, yes, this is properly a 12b1 jurisdictional issue. However, this court can look at that issue anew if they find that those very, very minute statements in each case did not directly affect the ruling in this case. In other words, you can disagree because you can say that's dicta. That's number one. Number two is if the McMillan case in this court is the en banc decision that says it's basically a first to file for the Fourth Circuit. The first case that comes along and controls, and then that no one can change that unless an en banc court changes that, except the Supreme Court can change that. And if you look at the case, at the circuits, 1st, 2nd, 3rd, DC, and apparently now the 9th Circuit, I haven't read that case, but I'm sure it says what the other cases say and what the Columbia Law Review article says, and that is that the U.S. Supreme Court has already said that unless Congress states clearly that a statutory rule is jurisdictional, it should be treated as non-jurisdictional. And that's called the clear statement rule. And that's why in all these other circuits, you've moved away from looking at this issue as a 12b1 issue and looking at this issue as a 12b6 issue.
So you're arguing it's not jurisdictional?
I'm arguing that it shouldn't be jurisdictional, although I agree that Carson and Carter both suggest that it is a 12b6, I'm sorry, a 12b1 issue. But I think the better rule is what the 1st, 2nd, 3rd DC Circuit and apparently now the 9th Circuit have said, and that is that the Supreme Court has said, look, unless the False Claims Act, in this case, that's not what they said in that case, but unless a statute says, this provision is jurisdictional, the default is it's not jurisdictional.
Which means we dismiss it with prejudice.
Which means you look at the issue as a 12b6 issue, that's all. I do agree with my opposing counsel that I'm not sure it affects the outcome of this case that much either way, except that when the court doesn't have jurisdiction, they have to dismiss immediately, as opposed to a 12b6 where you can grant leave to amend if there's some pleading defect. That would be the important distinction. But that's why the other circuits have followed the clear statement rule. That wasn't even addressed in Carter and Carson. And because it wasn't addressed and because it's the Supreme Court that has enunciated these rules, I think that this court could look beyond Carter and Carson and adopt the rules from the other circuits without running afoul of the McMillan en banc standard.
That's the one on the dam down on the Ohio River, McMillan?
I don't know the facts. I looked at the principle. And again, I don't want to be glib, but it was in effect the first to file rule for the Fourth Circuit. Thank you.
Thank you very much, sir. We appreciate it. We'll come down and greet counsel and then adjourn court until tomorrow morning.
This honorable